Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 140. Sounding increasingly like a darts score now. Anyway, we're back to doing three cases this time. We have a rare case where an employer was able to make changes to an employee's terms and conditions following a TUPE transfer. Given the amount of commercial activity we're seeing in the market at the moment, I thought it'd be useful to take a look at the circumstances in which employers can make legitimate changes after a TUPE transfer. Secondly, we've got an unusual case where the judge took it upon himself to consider the employment status of an individual, despite the fact that neither party was inviting him to do so. Thirdly, and finally, we have a clarificatory case dealing with the tribunal's powers to adjudicate on particular types of wages disputes. As if all this was not enough, I promised you an update last time round of how I got on when I saw Hamilton, the musical, and I'll give you my own, perhaps unique take on Hamilton, but we'll come to that at the end of the podcast. Please don't forget, you can access the podcast. It's on iTunes, Mayor Brown website, YouTube, and the Twitter feed, Nicholas Robertson at Nicholas, ROBER11. So, Tabora and others, and Mears Limited and others. The claimants were electricians. They had originally worked for Birmingham City Council and then gone through a series of TUPE transfers before they got to the current employer. And that sounds like a terrible pun. I didn't mean to say current employer, but anyway, you get what I mean. Whilst working for Birmingham City Council, the claimants had become entitled to a travel allowance. This had been introduced by the City Council back in 1958, at a point when the council had a number of depots across Birmingham. It was due to the need to reward electricians for loss of the opportunity to earn a productivity bonus caused by the fact they were travelling between depots, and that time didn't count towards the productivity bonus. However, over the years since 1958, the depots had closed. There was now only one depot. Jobs were now allocated on handheld computers, and the electricians used vans to travel to the jobs, and the productivity bonus no longer existed. In short, it was a thoroughly outdated and obsolete allowance. The previous employer, back in 2006, had questioned whether or not it was appropriate to carry on paying this allowance, but at that stage the employer decided to back off challenging it because it did not want to antagonise the trade unions. In 2008, the claimants then transferred to the respondent, the new employer, and the new employer took the view that the allowance was not, in fact, contractual. Therefore, in 2008, it just stopped payment of the allowance on the basis it wasn't an entitlement. But as a result of litigation brought by a Mr. Salt, who was one of the claimants, and unsurprisingly called the Salt litigation, the Employment Tribunal and the EAT established in 2012 that in fact the claimants were contractually entitled to the travel allowance. Therefore, the employer tried again. Now, it seems to be implicit in the EAT judgment that the employer had the right to vary contractual benefits payable to these staff. Well, this right to vary was exercised by the employer in 2012 when it said that any allowance would cease with effect from 1 September 2012 and it would no longer form part of anyone's contract of employment. The claimants asserted that this was a variation, which it clearly was, and it followed the transfer in 2008, which it did as a matter of date, time, logic. They said, therefore, it's an unlawful variation under Regulation 4.4 of TUPE. At that time, and this is a point I will come back to, Regulation 4.4 stated that in respect of a contract of employment that is or will be transferred under TUPE, quote, any purported variation of the contract shall be void if the sole or principal reason for the variation is the transfer itself or a reason connected with the transfer that is not an economic, technical or organisational reason entailing changes in the workforce. There was no doubt the change was adverse here. Therefore, the question was, solely, what was the reason for the variation? Before the Employment Tribunal and the EAT, the parties agreed on a certain number of points. Firstly, that the passage of time after transfer does not necessarily mean that the connection with the transfer has disappeared. Just because it's 5 years down the road, it doesn't mean it can't be connected with a TUPE transfer. Equally, both parties accepted that merely because the variation takes place against the background of a TUPE transfer, that does not make the TUPE transfer the reason for the variation. It's not a but-for test, context alone is not sufficient. The question which has to be answered is, what was the reason for the variation? Well, what happened? Well, the Employment Tribunal judge decided that the reason for the change was that the respondent believed that the allowance was outdated in the light of the current working practices of the electricians. The historic rationale for this bonus had long since disappeared. The tribunal judge concluded that the operative reason for the variation was therefore not the transfer itself, or a reason connected with the transfer. The claimants appealed to the EAT. In front of the EAT, the claimants pointed out that the SALT litigation, which determined the contractual entitlement, was caused by the TUPE transfer and the attempts to challenge the contractual status of the bonus by the new employer. Therefore, having taken a decision in the light of the outcome of the SALT decision, there was still a sufficient link back to the 2008 TUPE transfer. They also pointed out that the letter sent out by the employer in 2012 to the employees had said that paying the continued allowance was wholly unfair on the remainder of the workforce who operate in exactly the same way as the electricians and who have not presented any claims for travel allowances. The claimant said this showed there was clear intention to harmonise contracts, again, TUPE related. They also asserted that the respondent's belief that the payments were outdated was connected to the transfer. The claimant's working practices had remained unchanged since 2006, and so it was the new managers who arrived on the transfer, the TUPE transfer, who took a different view of things. The claimants also said that the decision to stop the payment of the allowances had clearly been made back in 2008 at the point of the transfer. That decision remained constant throughout. The respondents disputed all of this and said predominantly the establishment of the reason for the variation was essentially a question of fact for the Employment Tribunal. The EAT was very clear. The Employment Tribunal had decided that the reason, or principal reason, for ending the contractual entitlement was because the respondent believed the entitlement was outdated, and that was a finding of fact that was open to the Tribunal. The EAT did not accept that the SALT litigation, which had determined the contractual status, was linked to the TUPE transfer. If the SALT litigation was any part of the respondent's reason for the variation, it was simply that the SALT litigation was confirmation of a contractual entitlement to an outmoded payment. That did not create a sufficient link back to the transfer itself. Moreover, the Employment Tribunal was entitled to take into account that, before the transfer, the managers who had faced the issue previously in 2006 had thought that the allowance was unjustified, but had in essence decided not to raise the point at that stage. Quote, "The important point was that the operative reasoning, the belief that the payment was outdated and unjustified, did not arise purely on the occasion of, let alone because of, the transfer. It was a pre-existing belief or state of affairs." Unquote. When the respondents' managers arrived on the scene, they faced the same dilemma. And although the respondent, and therefore its managers, came onto the scene because of a TUPE transfer, that simply explained how the respondent came into the picture. It was not why the respondent questioned the payment of the transfer allowance. This was a dilemma that had confronted management, regardless of any transfer, and which continued from 2006 into 2008 and then 2012. On that basis, this situation was no different to a new manager coming into a workplace and learning of the entitlement. The fact that on this occasion the new manager arrived as part of a TUPE transfer was not why the respondents considered the transferees would cease to be paid. Equally, the reference to harmonisation was misconceived by the claimants. The employers were not referring to the need to harmonise terms and conditions within an occupational group, which often does relate to a TUPE transfer, but instead believed there was a need for fairness across different job groups, regardless of transfer. Well, on that basis, the Employment Tribunal's decision was upheld. So, what does this all mean? Well, my view is the case has some good points in it for employers who are receiving a business under a TUPE transfer, but there are some limitations. The case confirms broadly that employers are able to make contractually permitted changes post-TUPE in some circumstances. It's always necessary to look at the reason for the change, and mere proximity to or distance from a TUPE transfer is not an answer. Let's deal with the limitation, though. I think it's very important to recognise that in this decision there was proof that the management had, well before the TUPE transfer, considered whether or not the allowance should be removed on the grounds that it was outdated. Of course, in many cases an employer might arrive on the scene after a TUPE transfer and take the view that an allowance is outdated. But I think the EAT's acceptance of the employer's evidence of that point is very important. Clearly, it's much easier to say that a variation has no relation to a TUPE transfer if there is evidence that the managers, well ahead of any TUPE transfer, had the same intention to vary or the same concerns. Secondly, however, This was a decision on the wording of TUPE as it existed up until 2014. Regulation 4 now simply states that any purported variation of the contract of employment, quote, is void if the sole or principal reason for the variation is the transfer, unquote. It's no longer sufficient to point to a reason that is not the transfer, but is a reason connected to the transfer. Will this allow employers to come in after a TUPE transfer and say that they've come to a fresh view that a particular allowance is outdated, and that is not a reason for that is not connected to the transfer or a reason connected with the transfer? There seems to be little doubt that the Regulation 4.4 wording, which voids certain amendments, has now been narrowed. The key question is, how much has it been narrowed by? Well, in short, in Tabra and others, and Mears Limited and others, the employer was able to remove a contractual allowance which it believed was outdated, because that belief, the belief that it was outdated, was not sufficiently connected to the TUPE transfer to create a void variation of contract. So the next up is Potamianos and Prescott and Sprint Room Limited. Now this is a High Court decision which has had a bit of publicity. It's predominantly related to source coding and software matters, and that relates to the claim brought by Sprint against Dr. Potamianos. But there was a claim for unfair prejudice as a shareholder brought by Dr. Potamianos, who was a minority shareholder in the company. The full judgment is 100 pages long, so I'm just going to cherry pick one issue out of it, which does seem to have had some publicity in employment circles. The company was set up, Sprint was set up to make electric motor drives, and Dr. Potamianos was someone who was able to help the company acquire appropriate expertise in the digital motor controller area. The good doctor joined the company through his own service company, which contracted directly with Sprint in 1997. There was then a further contract in 2000 and a consultancy agreement in 2015. Dr. Potamianos was the company's sole programmer. The company he fell out in 2015 or so, and a dispute arose about who owned the source code that had been written by the doctor, and whether or not Dr. Potamianos, as a minority shareholder, was being treated in an unfairly prejudicial way. Well, the matter ends up in front of a High Court and the Chancery Division judge, and both parties seem to have turned up to court prepared to argue the interpretation of the three main contractual documents which have been entered into around the source code and software claim. However, the judge seems to have had other ideas. The judge commented early on in the judgment that a number of the arrangements seemed to be motivated by tax avoidance objectives, and although he rather dryly suggested that neither side suggested the court's approach to any of these agreements should be coloured by this consideration, it is impossible to ignore, unquote. Well, the judge reviewed the cases which discussed the distinction between an employee and a self-employed contractor, someone who's in business on their own account. He took the view that there was a clear public interest in people paying the taxes that are properly due and not escaping payment of due taxes by devices, including false descriptions of their contractual relationships. It was up to the court then, he said, to look at the issue as to whether or not Dr. Potamianos was in fact an employee of Sprint, even though none of the contracts asserted this, and none of the parties appearing before the court asserted this. The judge decided he needed to look at the true relationship between Sprint on the one hand and Dr. Potamianos. He took the view that if the contracts had been wrongly described to deceive HMRC, that did not make the contracts illegal. It was better the court declared the true legal position to the parties and left it to HMRC to claim the tax and penalties that would then or may then be due. On the facts of this case, it would mean that the source code claim would be won by the company if Dr. Potamianos was an employee of Sprint rather than a self-employed contractor through his own service company. Well, the High Court decided that Dr. Potamianos was in fact under a personal obligation to perform technical services which were the subject of the 1997 contract. If this had been performed under a contract made directly between him and Sprint, he would have been regarded as an employee of SEL. He did not perform any other services for anyone other than Sprint, and the services he performed were exchanged for fixed levels of payments, i.e. he didn't take the profit or the risk of a loss on his work. He was part of the Sprint organisation. He did not hire helpers, the judge said, or engage in any significant investment or management or provision of the provider's own equipment. On that basis, the 1997 contract, the judge said, did not correctly describe the true relationship, and the court came to the conclusion that the true relationship was employer and employee. On that basis, Sprint won that particular issue, but not for the reasons it expected. Well, as I say, the case has received a bit of publicity because of the judge taking the issue on himself to investigate whether or not Dr. Potamianos was an employee. We can certainly understand why the court took the view it did if it felt these arrangements were motivated solely by tax considerations to deceive HMRC. The bit that I do have some trouble with, however, is the judge appears to have assumed, or maybe found very easily is the way I put it, that there was a contract directly between Sprint and Dr. Potamiamis, which he could then construe as an employment contract. My reading of the case, as I say, it's a long and lengthy and complex case, is that the documents were set up so there was no direct personal contract. In the circumstances, as we know from other cases, it's more of a reach for the court here to have decided that the individual was an employee of Sprint, because that, in essence, involved identifying a brand new contractual relationship rather than correctly categorising an existing contractual relationship. Cases such as James and Greenwich Council did indicate some years back that in many cases the courts would draw back from inventing contractual relationships rather than categorising admitted contractual relationships one way or the other. It would only imply a direct contract, according to James and Greenwich Council, where it was necessary to do so. I don't know if the approach in this case signifies new judicial activism or it's a one-off. Given the outcome, I do wonder if either party might look at an appeal. Well, overall then, in Potamiamis and Prescott and Sprint Room Limited, the court identified an employment relationship between Dr. Potamiamis and Sprint, although neither party was asking the court to make this finding. Anyway, it's a salutary lesson overall, and clearly both parties look like they've lost out. I don't know, I only know what I read in the judgment, but the individual loses out on the source code issues, whereas the company may well end up with a significant tax bill going back many years in the light of the judge's findings. It does sound to me as if neither party is likely to be happy with the outcome of this particular case. So, third and final case, Agarwal and Cardiff University and others. This was one of two appeals that were joined in the Court of Appeal to consider a very simple jurisdiction issue. It's also been a point that I have to say has baffled me for some time, that there could be any dispute about this particular point, although I think I have to recognise, particularly at the employment judge stage, there was binding authority that probably required them to decide matters in a particular way. Nonetheless, we now have a Court of Appeal clarification of the law, and as such I think it's helpful because it offers practical assistance to claimants, and equally employers need to be aware of this case in the context of any dispute over wages. Factual background: in Agarwal there was a claim for salary. A dispute had arisen because the claimant had been off for a prolonged period of sickness absence, and the amount of pay to which she was entitled was being disputed. It turned on the interpretation of the contract. In the case this was joined with it, the Nexus case, the dispute arose around the interpretation of a pay agreement for staff on the Tyne and Wear metro system, and that claim related to shift allowances and whether or not they were entitled to it, and that too turned on the interpretation of the pay agreement. Both cases, employees brought claims based on Part 2 of the 1996 Employment Relations Act, alleging there had been an unauthorised deduction of wages. I'm afraid, confession time, that I still think of this as the Wages Act provisions, although I think the Wages Act was in fact repealed in 1996. Whatever next, they'll be changing the title Article Clerks. Anyway, the relevant provisions in the 1996 Act the relevant provisions for this, our purposes, start at Section 13. This provides that an employer shall not make a deduction from wages of a worker employed by them unless it is required or authorised by virtue of a statutory provision or a provision of the worker's contract, or the worker has previously consented to this deduction in writing. In order for a provision of the contract to be a relevant provision, it must be a provision of a contract, have one or more written terms laid down in the contract, a copy of that written contract has been given to the employee before the deduction in question, or it's one or more terms of the contract, whether written or oral, but the employee has been notified in writing of the oral or written term before the deduction in question. The remedy for an unauthorised deduction is via an employment tribunal, as I say, is to claim under the Employment Rights Act Part 2. For those of you with long memories, you may remember that there was originally a dispute as to whether an employer could be sued under the Wages Act where there was a dispute over the wages, or whether there had been simply a failure to pay. This was ultimately answered very clearly in Delaney and Staples back in 1991, where we said that any shortfall in payment amounted to a deduction, and on that basis a dispute on whatever ground as to the amount of the wages properly payable was within the scope of the legislation. All of this, I think, probably seems very obvious. But, there are a series of parallel cases around Part 1 of the 1996 Employment Rights Act. This is to do with the obligation to provide a written statement of particulars of the principal terms of the contract of employment. Section 1 statement. The courts there for many years have accepted they are not, for Part 1 purposes, to interpret the contract whose terms they have identified. they're not able to amend or introduce terms where none have in fact been agreed. Now, the case which put this all beyond doubt is Southern Cross and Perkins. But, as a result of cases in the EAT, a question arose as to whether the Part 1 approach, tribunals can't interpret Section 1 statements, /contracts, also applied to Part 2. This meant that where the reason for the dispute about the alleged underpayment of wages turned on the interpretation of the contract, in some cases tribunals decided they were precluded from dealing with it. Somewhat unsurprisingly, the Court of Appeal thought this was plainly wrong in relation to Part 2. Delaney and Staples in the Court of Appeal had clearly indicated that these interpretation issues were the sort of issues that could be determined by an employment tribunal. Southern Cross and the other cases on Part 1 were just not relevant to the interpretation of Part 2 of the Employment Rights Act, which is what contains the old Wages Act provisions. There was also, the court said, no good policy reason for carving out of the Employment Tribunal jurisdiction the type of process necessary to resolve a wages claim turning on a disputed interpretation. I think the Court of Appeal's conclusion is, with all due respect, plainly right. But it's surprising the confusion had been allowed to develop at the EAT level about the interplay between Part 1 and Part 2 of the Employment Rights Act. One part is dealing with the identification of terms of the contract, the other is dealing with contractual disputes for a contract in existence. However, I do think the Court of Appeal's decision is helpful. It means that where there is a dispute as to wages, the tribunal will have jurisdiction to deal with those disputes. Employers will not be encouraged to try and find an interpretation dispute, to try and take the matter outside the jurisdiction of the tribunal. Equally, from an employee's point of view, this will mean that disputes can be resolved in the way that undoubtedly Parliament probably intended, i.e. in the tribunal, and hopefully relatively efficiently and speedily in front of judges experienced in dealing day in, day out with employment disputes. So, overall, Argyle and Cardiff University and others, Court of Appeal decides that tribunals can deal with unlawful deduction cases where the reason for the deduction is a disputed interpretation of the contract. So, thank you very much indeed for listening. I said last thing that I'd give you some views on Hamilton. I went to Hamilton with really high hopes. I'm not a musical fan in the slightest. And the thing that I found was that although I went with the best of intentions, it didn't do it for me. I found that the music didn't engage me. I didn't find it moving. It was sort of interesting, but as I commented to my wife afterwards, I could probably have walked away at half time and not worried about what happened to any of the characters. So do go see it. Certainly do not take my views on Hamilton as anything close to gospel. But for me at least, I chalk this up to another musical that did nothing for me, and that probably tells you more about my prejudices, my music taste, than anything else. So, having got that confession out of the way, do hope you'll join me for episode 141 in a couple of weeks' time, and in the meantime stay safe, and as always, just to confirm, no employees were harmed or mistreated in the making of this podcast. Thanks for listening.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.